Yeah.
Hello. How's it
Hello,
going?
Prof. How are you?
I'm doing well. How about you guys?
Surviving.
Whoops.
Good.
Thought I knocked out my earbuds. Didn't get my tennis game in this time, but I got my run in, so barely. So all you other people, I'd like to see you unless you're in your pajamas or or your or whatever. Yeah, I don't want to invade your privacy, but it's nice to be able to see each other's faces.
Mhm.
Noli, are you on top of the world today? The background, is that like the world?
Who's that?
And Noli, I'm trying to figure out if he's on top of the world, because like
Oh,
with his background,
yeah, your background's got like
it's cool.
it looks like the world with sunrise about to occur. Emily, we're talking to you.
What is it like?
Bethany was asking, are you on top of the world? It looks like you have world behind you with,
okay, yes, yes. And I have no clue. That's why I can't even pick you are talking to me. It's some people in the house who are doing this. I have kids, so
some
they
people.
know this.
Are they related to you? Are they people related to you? What do you have? Four
Yeah,
kids or five
Cat
kids?
filter.
That's right. Yeah, it's my kids. Yeah, they do stuff like this. Yeah, I wasn't giving away. Yeah, it's a beautiful background, isn't it?
It is beautiful.
Yeah,
Very,
yeah,
very nice.
yeah. I think it must be inspired by the shuttle. My 12-year-old is very keen on science and stuff like that. So he was,
Great.
yeah, yeah.
Well, I'm sitting on my front porch, and my house was built in 1830, so you can see it has sort of like
Oh, cool.
old rocks.
Yep, 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 yep.
So let's see, is everyone on this call taking the test or no? You haven't yet, Emily, have you?
Nope, 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 nope.
Okay, so
not
I
yet.
won't go through.
Yep.
I won't go through questions on the test. We can do that next week. Look like a little bit under a half of folks have done it so far. And I only really got around to grading those who did essays. I got around to grading them last night. So your score should reflect your essay if I think you wrote one. So if you think your score doesn't reflect your essay, then send me a note and I'll make sure I didn't miss your essay. Okay, anybody got anything in the news? I can't say as though, I don't think that, the Supreme Court's got some interesting voting rights case they argued today, but I'm not thinking that I haven't actually seen a First Amendment case exactly. They will have one coming up that'll be good for us to discuss about student speech, where a cheerleader didn't get on the cheerleading club and did a social media message saying nasty things to her cheerleading teacher. Hi, Tabitha. So let's see. So I really don't have any particular First Amendment issues. I can't remember if we talked about this one before. And this is sort of a good lead into what we'll be doing next week. Next week we have I'll send you a link for a speaker from the Pulitzer Center on Crisis Reporting, who has been, her last name is Staub, S-T-A-A-B, Marina Staub, and she has been covering the protests in Portland for several months. I mean, almost a year, I guess. The sort of post George Floyd protests in Portland, which have sometimes been very raucous and I mean, at least one person was killed there, maybe more, but I know there was one. And so she has sort of an interesting point of view. She is a freelance photographer. I mean, she considers herself a professional journalist, but she's more from the sort of activist side and the left activist side. She was involved in a lawsuit that's still working its way through the federal courts to try to claim First Amendment protection from what she and others claim to be the police singling journalists and court observers out during protests. Of course, you know, there also have been some very raucous protests from both the left and the right in Portland. So I think she'll be interesting to talk to. We will listen to her speech, and in lieu of class next week. She's here on March 11th. I think it's at 4:30. I'll send you the Zoom. If you can't make it, I'll make sure that I record it. There'll be an opportunity to ask her questions. I was saying that there was actually a recent court decision here in St. Louis that relates to the rights of journalists at demonstrations. It harkens back to the Ferguson Michael Brown demonstrations in 2014. There was a crew, a camera crew from Al Jazeera that was on the street recording a demonstration, and police said that they had ordered everybody, that had ordered it as a illegal assembly and ordered everyone to disperse. The sort of videos don't pick up any such recording. Police officers used rubber bullets and were shot at the crew. Then they fired a tear gas canister at the crew. And the question, which is, it's not like directly a First Amendment question, but it has a First Amendment issue right behind it. The question is whether or not the police officers have qualified immunity. I don't know if you guys have heard that term, qualified immunity. It's one of the things that protects public officials from citizen lawsuits. And basically what qualified immunity basically says is that a public official can't be sued unless they have violated a person's constitutional or statutory right, and that right, it has been well established. Everybody knows it's a right. So qualified immunity oftentimes will extend to a police officer or another public official in a situation where maybe there's never been a really clear court decision before that a particular action was unconstitutional. So the police officer in this case, who was a member of a SWAT team from, I think, St. Charles County, said, well, you know, there's never really been a court decision that's exactly like this, where, you know, where the police fired a tear gas canister at the news media covering a raucous demonstration. And the 8th Circuit Court of Appeals, so if you go back and you look at that map that I have on the homepage of where the various courts of appeals are, it's in St. Louis. The 8th Circuit Court of Appeals, which is in St. Louis, and is really a rather conservative court of appeals, ruled that the right of news gatherers, a TV crew or reporters to gather news at a demonstration like this one was well established. As a matter of fact, they sort of surprised me. They cited the case that we read, Brandsburg versus Hayes. You remember Brandsburg versus Hayes was the case where Supreme Court decided that, while news gathering is protected, it didn't extend to a reporter protecting a confidential source. Well, the Eighth Circuit Court of Appeals quoted language from Brandsburg versus Hayes saying the first part of that news gathering is protected under the First Amendment. And so therefore it should have been clear to this police officer he couldn't fire tear gas at this Al Jazeera crew. And so therefore he doesn't get qualified immunity. Now the case goes back to the trial court and they'll have witnesses and everything. So it's not the final word, but it was an interesting ruling on this issue of qualified immunity. And qualified immunity is something that in almost all of these various police reform bills that are around the country is sort of a major issue that comes up. Like Illinois just passed a major police reform bill, rather controversial. Police officers, unions and associations are opposed to it. And even though it has a number of reforms, such as trying to get rid of cash bail, I don't believe it touches the issue of qualified immunity. But some other reforms around the country have touched on that. And it's sort of like a major, I believe, although I wouldn't stake my life on it, that the national George Floyd reform bill that Biden just yesterday endorsed may have a limitation on qualified immunity. Anyway, that's just sort of so that's something that's in the news here in St. Louis, and it's a little bit of just a little appetizer to set you up for next week's discussions with the Pulitzer speaker. Any questions about any of that? Okay, New York Times versus Sullivan. Who wants to do New York Times versus Sullivan? Bethany, you sent me a brief. Would you like to do that one?
Sure, yeah, I would like to do that one.
Okay, go ahead.
All right. So New York Times versus Sullivan, maybe if I can talk today, I'll do it. So basically the New York Times published a full-page advertisement by supporters of Martin Luther King Jr. that criticized the police in Montgomery, Alabama for their mistreatment of civil rights protesters. And the ad had several factual inaccuracies in it. Some of these inaccuracies were the number of times that Dr. King had been arrested during the protests, and whether or not students had been expelled for participating in the protests. And the police commissioner in Montgomery, L.B. Sullivan, is the one who sued the New York Times in the local county court for defamation. He argued that the inaccurate criticism of actions by the police department was defamatory to him because it's his duty as police commissioner to supervise the duties of the department. And Sullivan sent a letter to the New York Times asking them to print a retraction statement, and they did not honor his request. So he filed a libel lawsuit against New York Times. And in the Alabama state court, the judge ruled that the ad was defamatory, and he was ruled $500,000, but the New York Times appealed to the Supreme Court, and the Supreme Court ruled that the decision of the Alabama state court was in violation of the First Amendment, because the decision defended the free reporting of the civil rights movement in the southern part of the United States. And that vote in the Supreme Court was unanimous, so it was a 9-0 vote. And basically the opinion of the court was that a newspaper cannot be held liable for making false defamatory statements about a public official unless the statements were made with actual malice. And Justice William Brennan Jr. cited the opinion that public discussion is a political duty and that this should be a fundamental principle of the American government. That's kind of what I got.
You gotta unmute me. I muted myself, so I have these wind chimes here that make a noise, and I was trying to. I didn't want to interrupt your summary. Anybody have anything? That's a very good summary. Anybody have any facts from it? Any additional facts they want to add? This is a super important case. I mean, anybody who knows anything about the First Amendment or about who's interested in media or journalism needs to know about this case. I mean, one thing to know is that, well, one thing that Bethany pointed out, this is an ad, not a story. You need to know that for one of the questions on the next test. It was an ad, not a story. They didn't. If they had checked their archives, their morgue, they would have seen that a number of the statements in the ad were wrong. Bethany laid out some of them. A number of times, King had been arrested. He'd been arrested 4 times, not 7, like the ad said. Students were not singing "My Country 'Tis of Thee," they were singing the national anthem. The students were expelled by the State Board of Education for not leading the demonstration at the Capitol, but rather for demanding service at a lunch counter in the Montgomery County Courthouse on a different day. Most of the students, but not the entire student body, protested. They protested by boycotting class, not by refusing to re-register. And the biggest mistake was the claim that armed police had ringed student protesters at Alabama State and padlocked their dorm to starve them, quote unquote, starve them into submission. But the dorm had actually not been surrounded, and the officials were not trying to starve them. Was Sullivan's name in the ad? Was he named? His name was not in there at all. And you know what? If the Supreme Court had wanted, the Supreme Court in general tries to, it is thought to be a good practice by both liberal and conservative justices on the Supreme Court, although they don't always follow their own advice, to resolve a case without going farther than they need to go. Well, they could have resolved this case. They could have resolved this case by saying that Sullivan wasn't named and you can't win a libel case if you're not named. But then, you know, that, are you coming out here? Should I go in the backyard?
That'd be nice. I don't know how long I'm gonna stay though.
Okay, I'm gonna surrender the front yard to my wife and move to the backyard. So she does. Last thing she needs to hear is all this blah 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 about New York Times versus Sullivan. We have a granddaughter who is always saying that she's tired of hearing all the blah, 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 politics, blah, 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 Trump. So that's a term that's gotten into our language. So the Supreme Court could very easily have just said, Sullivan's not named. You can't win a libel case without being named. And end of case. But that wasn't what they were really concerned about. They were concerned about what was going on in the country at the time. This was the early 1960s. The civil rights movement was just getting a lot of steam. New York, the oral argument in the Supreme Court on New York Times versus Sullivan was after Martin Luther King's famous March on Washington in the summer of 1963, you know, where he made I Have a Dream speech, and it was before passage of the Civil Rights Act of 1964, which brought an end to legal segregation in the South. So this was, and the other thing to keep in mind is this was the Earl Warren Supreme Court. It's not the Supreme Court that we have today. This was the most liberal Supreme Court at the time of New York Times versus Sullivan that the United States has ever had. And maybe, and I think probably the most liberal one it ever will have, with at least within my lifetime. Given, you know, that now it's a rather conservative court. Earl Warren had been the governor of, it's called the name of a Supreme Court is always takes after the name of the Chief Justice. Chief Justice Earl Warren was the Chief Justice from 1954 until 1968. He had been the Republican governor of California before he became Chief Justice. One of his very first decisions as Chief Justice was Brown versus Board of Education, ending segregation of public schools in the United States. When I was a kid, if you took a trip around the South, there were billboards up all over the place, impeach Earl Warren. And then as you know, as time went on, I mean, the Supreme Court continued to be very involved in school desegregation. You know, at some point during the big 1957 Little Rock riot, you know, around the desegregation of Central High School in Little Rock, the Supreme Court had a famous decision where they said, you know, it's the Supreme Court that says what the Constitution means. It's not something that a state governor or legislature can have a different view about. There's only one view that counts, and that's what the Supreme Court says about the Constitution. And then, you know, around the time of in the early 60s, as the civil rights movement is gaining momentum, the Warren Court had all sorts of big decisions that, you know, you sometimes will hear about: Miranda, right to remain silent, right of a suspect to have a lawyer. There was a case called Mapp versus Ohio, which was if the police conduct an illegal search, the evidence oftentimes cannot be entered into a criminal trial against you. One person, it was actually called one man, one vote. One person, one vote. A lot of the legislatures back then were very represented rural areas a lot more than urban areas. And that was to one person, one vote said districts have to be roughly the same size in the number of people in a legislative district. So there were these really big decisions on, you know, equal rights, criminal rights of criminal procedure, free speech and freedom of religion decisions. You know, that this was the court that basically decided that the states can't determine that every public school kid has got to say the Lord's Prayer at the beginning of the school day. So all of this was going on, and New York Times versus Sullivan was, you know, every bit as important as any of the other decisions that I just mentioned, because it was like this revolution in the way in which libel law and defamation was handled in the American court system. So defamation is when you wreck somebody's reputation. Libel is when you do it by print. Slander is when you do it with, you know, speaking. Twitter accounts as libel. Sometimes people call it twibel. before New York Times versus Sullivan, the the defamation and libel and slander, that was all something that was handled by the state courts. I mean, I don't believe that there is a federal libel law. It's all state court. It's all state law. And so for the U.S. Supreme Court in New York Times versus Sullivan to impose on libel a national constitutional standard was a revolutionary change in constitutional law. I mean, one of the things they were concerned about was that New York Times versus Sullivan wasn't the only case that was underway at this time. I mean, there were lawsuits all throughout the South by segregationist politicians against basically the Eastern press. The New York Times faced in the South $3 million in libel and criminal libel verdicts, all flowing from their civil rights coverage. CBS had another 1.7 million. And so there was actually a threat that the libel lawsuits by segregationist Southern politicians could actually force the big Eastern and national press out of the South, and it was the media coverage of the South, along with the power of the civil rights movement itself, that was changing the minds of Northerners. There were these television pictures of Bull Connor, who was sort of a famous, nasty Birmingham police chief, sicking vicious police dogs on little young kids who were protesters. There are pictures of people being pulled out of lunch counters and spat upon. There are pictures of fighters with powerful fire hoses trying to break up peaceful demonstrations in Birmingham. Of course, there was the 16th Street Baptist Church dynamite bombing, killed it's either 3 or 4 children in the basement. All of this is happening in this period around the time of New York Times versus Sullivan. And so the Supreme Court was wanting to provide protection for the press to be able to report on what was on the civil rights struggle in the South, because it was that reporting that was actually bringing about the change in civil rights laws around the country. So, any questions about that? So it's important to remember New York Times versus Sullivan. It's equally important, really. It's as much a civil rights case as it is a First Amendment case, but it's really important in both respects. It protected the press's coverage of the civil rights movement in the South, which was a major impact on the civil rights movement succeeding. And it has going forward been a great protection for news organizations, faced by public officials who are wanting to sort of fight back at unfavorable news coverage. So after New York Times versus Sullivan was announced, the decision was announced in 1964. It was that summer that Lyndon Johnson was able to get the 1964 Civil Rights Act passed. In quick succession over the next few years, the Fair Housing Act passed, the Voting Rights Act, And then, you know, it was by the 1970s that the Equal Rights in Education Act, like Title IX, guaranteeing women equal treatment in educational programs passed. So it was this, it ignited a period of legislative reform in civil rights laws affecting the rights of blacks and of women. As a matter of fact, a funny sort of side story this doesn't relate to New York Times versus Sullivan itself, but when there was a senator from Virginia, his name was Smith, who, you know, the Civil Rights Act had been blocked for years by the filibuster, by Southern Democrats, and so they were sort of getting down. They barely had enough people to block the Civil Rights Act, and Senator Smith thought he had a great idea about how to make sure that it didn't pass, and that was to add the word sex in along with race, so it would cover so it would outlaw sex discrimination as well as racial discrimination, and because he thought there's no way in which this, you know, Senate, that at that point, I think there was one woman, Margaret Chase Smith, from a Republican from Maine. There's no way this Senate is going to approve a bill that makes sex discrimination illegal. Well, he was wrong about that. That's why, you know, when the Supreme Court, you know, like last year when they were trying to interpret that word sex in Title VII of the Civil Rights Act, and, you know, what does it mean? Does it include, you know, lesbians and gays and transgendered, et cetera, et cetera? I mean, you can't exactly go back to what was the intention of the person who wrote that into the legislation, because the intention of that person was, you know, not to grant anybody protection from sex discrimination, much less protection from any kind of discrimination. So you can't exactly go back to the original intent of the drafter of the law. So when they say malice, actual malice is what has to be proven. What do they mean by that? Do they explain anywhere in the decision what they mean by that? Does that mean do they have to prove that, you know, like a reporter was really mad, you know, so like said to somebody, I'm going to get that politician? Is that the kind of proof they need, or is there something else? And if you're trying to talk, you need to unmute yourself. Were you trying to say something?
Yeah, I was trying to say, wouldn't that be to say that the burden of proof lies with the one who is alleging to have been defamed, and that he should be the one to bring forth the evidence that his status has been lowered in the...
Right. So Sullivan, the police commissioner, the public safety commissioner, would have to show that that his reputation had been wrecked, and here's how it had been wrecked. But he'd also have to show that, have to prove actual malice, and, you know, to do that, he wouldn't have had to prove, you know, that the people who wrote the ad were you know, angry at him or had said something about getting him. All you have to prove, what actual malice actually means, the court said, is reckless disregard for the truth, knowledge of falsity. So for example, there's a follow-up case which we did. It was not amongst the reading. It was one of the cases where the Supreme Court extended New York Times versus Sullivan to public figures, not just public officials like like Sullivan, but also public figures. In this case, it was Bear Bryant, who was if you were as old as I was, you would know his name as being a famous coach of the University of Alabama football team. And Sports Illustrated had a story basically saying Bear Bryant had fixed some football games. And, but they hadn't called him up and checked out the story as much as they should have. And so that was considered, by failing to get, an adequate comment from the person who was being accused, that was considered to be reckless disregard for the truth. Another way to say what actual malice is knowledge of falsity. So if the writer or the speaker knows what they're saying is false, then that's proof of actual malice. So actual malice actually means reckless disregard for the truth, or knowledge of falsity. That's sort of a more specific way to explain what it is. And so public figures is complicated because it oftentimes is sort of an individual thing, whether a person is a public figure. I mean, a public figure can be, a person can be a public official or a public figure for some purposes and not for others. For example, there's a case, and I think I asked a question about this on one of the tests. There's a case involving a guy who was a lawyer in the Justice Department, Organized Crime Division. And then he retired and he went off to Cleveland or Cincinnati or someplace to practice law. And the Supreme Court said, for the purposes of any story involving what he did while he was a Justice Department official, he's covered by New York Times versus Sullivan. But for the purpose of anything he did as a lawyer in practice in Ohio, he was not a public figure. So then it's easier to prove. It would be easier in those instances for him to prove a libel case. He wouldn't have to, that lawyer wouldn't have to prove that the news organization that wrote about him had engaged in actual malice. It'd be enough to show that they were, that they had been carelessly wrong. Whereas, if you're trying to prove, if it was a news organization that had written about something he had done as head of the organized crime task force, then the lawyer would have had to prove that the news organization had engaged in actual malice, that they had been reckless disregard for the truth. It wouldn't be enough to prove that something was wrong.
Prof?
Yes.
Defamation also assumes that if I don't command any reputation in the eyes of the public, I cannot be defamed. Can I?
Well, I mean, the extent to which your reputation is harmed, that sort of goes to the issue of damages. And so, if you don't have much of a reputation to protect, I suppose that it's going to be a lot harder for you to prove damages.
That's right.
I can't remember, for example, whether or not that one of the two female entertainers who said they had had sex with Trump, whether she sued him for defamation. But I think her lawsuit was about different. I think she actually sued him for I think she may have sued him for lying and saying that he hadn't had sex with her. So, her reputation, I don't know how you figure her reputation. It's not so, it may not be so great from the point of view of being an adult entertainer, but on the other hand, she probably makes a lot of money doing that. So there's actual loss of, well, I don't know. She probably ended
Mhm.
up being able to make more money as a result of that than less. So I don't know how you figure that one out. But you're right. You do have to show some sort of damages, and so the extent to which you have a reputation that's going to be damaged is something that's relevant.
Yeah, I'm reminded of the two parallels that are going right now on mainstream media. One regarding Andrew Cuomo, and the other, what's his name? Is it Crawford?
I know
The
Cuomo. I know what you're talking about. I'm not sure if I know the other one.
Yeah, one is a Republican youngest congressman who's on a wheelchair. I forget his name. I'm
Oh yeah,
sorry.
yeah. The guy who made up a story about why he should get about being in a traffic accident. So
Yeah.
this is a guy who's what is he a representative from, is it Virginia or South Carolina? And he said that he was in a traffic accident and his friend ran away, uh, uh, and so he ended up in a wheelchair, and actually his friend pulled him out of the wreck. Um, so yeah, that's another case in the news. And Cuomo, I'm sure you all have seen that a number of women, I think there are now at least three. I suspect that with every passing hour there'll be another. Have said that he engaged in unwelcome advances. Um, doing stuff like, "Can I kiss you?" or "Do you like to have sex with an old man?" or um, although he didn't put that in terms of an
He
old
likes
man.
to date. He wants a 20-year-old girlfriend, I think he said.
Yeah, he doesn't have anything against a 20-year-old girlfriend. And what does she think about having about sex with a 60-year-old man? I mean, stuff like that. None of it. I guess in one case also he is said to have kissed a person in his office when without any invitation. So yeah, I don't think he's going to last too much longer, to be honest with you, as the governor of New York. But I don't know. These things change so fast. I mean, sort of society standards for this. If you went back 10 years, certainly 15 years, but probably if you went back 10 years, none of these three cases that have come out so far would have resulted in a politician losing their job, because none of them actually involved, well, an unwelcome kiss would involve an assault, but none of them involved, the others didn't involve any kind of, touching or assault. Um, and then, but if you went back, say 3 years to when the Me Too movement was at its peak, I mean, you'll recall that the Minnesota Senator Al Franken was forced to resign because of things things he had done that were sort of like what Cuomo did, and so the fact that Cuomo is still hanging on, might mean that society is sort of calibrating, what it is that it won't tolerate. I think Democrats got tired of Al Franken has to quit uh, for a number of cases where he's handsy with women, uh, and Donald Trump gets elected president with 20 cases of alleged assault of women, and a seeming public declaration that this is the way he does things. So I think Democrats got tired of forcing Democrats out. So we'll see what happens with Cuomo. But he couldn't. Would he have getting back to defamation? he could file a lawsuit against these women, but
Mhm.
he wouldn't get anywhere with it. Okay, so why don't we go on to Jerry Falwell? Who wants to talk about the Falwell case? You're on, Caleb.
I could talk about that.
Okay.
Okay, so the case is between Hustler was in 1997. So Hustler magazine and Larry C. Flint versus Jerry Call. Oh, sorry, this is the wrong. Falwell? Did you say Falwell?
Falwell, that's it. Yeah.
Yeah, okay. So that's the case between Hustler magazine and Larry C. Flint versus Jerry Falwell. So Hustler or Jerry Falwell, he sued Hustler magazine for libel.
So who was Jerry? Do you know anything about Jerry Falwell?
He is a televangelist and a political commentator.
Well, yeah. I mean, he's dead now. It's his son who is the current one. At the time that this occurred, the senior Falwell was sort of known as the leader of what was called at that point the moral majority. I don't know whether people use that term anymore. This was a very strong religious supportive group behind, like, Ronald Reagan and Republican candidates, and Jerry Falwell was the best known amongst them. And now it's his son who does Liberty. Well, I guess is at Liberty University, and he's gotten himself into some difficulties recently. But yeah, so we're talking about the senior Falwell, sort of the epitome of at this point, at the time of this parody, he was the epitome of uprightness.
Yeah.
So go ahead, Cal.
Okay, so the reason he sued them is because Hustler magazine had a parody ad in their magazine that depicted him as a incestuous drunk, and so that's what happened. He sued them, and the court ruled in favor of Hustler magazine, saying that the parody could not have been reasonably considered believable. So therefore, the court held that the emotional distress inflicted on Falwell by the ad was not a sufficient reason to deny the First Amendment protection that is critical of public officials and public figures.
Who wrote the opinion for the court? Do you know? Anybody?
I'm not certain.
For people who follow the court closely, this was sort of a surprise because the opinion was written by William Rehnquist. William Rehnquist was the Chief Justice of the Supreme Court at this point. And I mean, Rehnquist was he was the epitome of a conservative justice. He had I once sat next to a lawyer at a First Amendment conference who had filed a friend of the court brief. They're called an amicus brief, friend of the court brief in Hustler v. Falwell. And she had filed it on behalf of cartoonists. And it was just a compendium of all sorts of political cartoons. And they had found out that when Rehnquist was a young man and when he was a law student at Stanford, that that he was really interested in political cartooning. And so they realized that this was a great way to appeal to him and try to get him on their side. They did decide to exclude one cartoon from this friend of the court brief, which was a cartoon of Rehnquist in a Ku Klux Klan outfit denying voters, Hispanics, the right to vote in Arizona. That had been when Rehnquist was nominated both as a associate justice and then later as a chief justice. This had been one of the controversial things that he had been involved in, because he had been accused of having been an election judge in Arizona as a young man and having, tried to keep minorities from voting. Anyway, so they found out that he really liked cartoons. They left that cartoon out and put a bunch of others in. And, if you read his opinion, he specifically mentions, the Thomas Nast, there are some famous Thomas Nast cartoons about, like Boss Tweed and the corrupt democratic city political machines of the 1800s, which he thought were great. He has some sort of line in here that, the parody in this case was a poor cousin to the great Thomas Nast cartoons, but nevertheless still protected by the First Amendment. The parody itself, what it basically says is that Falwell had sex for the first time with his mother in an outhouse. Now, so Rehnquist, the crazy thing about this opinion is Rehnquist applies New York Times versus Sullivan. Well,
Mhm.
I mean, clearly, the Hustler and Larry Flint knew the falsity of Falwell having sex with his mother for the first time in an outhouse. They knew that was false. And so, how one actually applies New York Times versus Sullivan to this case, where the author knows the falsity of what's being said, is a little bit hard to follow. But it was seen at the time as being this monumental victory for New York Times versus Sullivan. And here's why. Even though, as Bethany pointed out, the New York Times versus Sullivan was 9-zip, a lot of people on the court didn't feel comfortable about it. One thing was that in the years after New York Times versus Sullivan, remember, we're talking about more than about 30 years having passed between New York Times versus Sullivan and the Falwell case. And in the ensuing time, a lot of the justices, saw the press doing stuff they didn't like. For example, one of their colleagues who had been on the court at the time of New York Times versus Sullivan, Abe Fortas, had been nominated to be the Chief Justice to succeed Earl Warren, but a newspaper revelation showed that he had received legal fees from a party who had a case before the Supreme Court. And so he not only didn't get to be Chief Justice, he also had to resign from the court. There are also lots of stories about William O. Douglas, who was one of the liberal members of the Warren Court, and his sort of like, he had a bunch of younger wives, one of whom had been a law clerk of his. So there was a lot of coverage of that the justices on the Supreme Court were not too happy about. So there actually was a lot of and then the Nixon appointees to the Supreme Court, Rehnquist and Lewis Powell and Warren Burger and others, took a much more conservative view towards the Constitution. So they weren't fans of New York Times versus Sullivan in the first place. So people really thought that it was possible that the Supreme Court would overturn New York Times versus Sullivan. But then when Rehnquist, who had been one of the leading critics in dissenting opinions, the critics of New York Times versus Sullivan, embraced it in the Falwell case and used it to uphold this, speech that's certainly on the edges of what should be protected. That was a resounding sort of final embrace for New York Times versus Sullivan, and showed it was never going to get overturned. That it was on solid ground. Parody is one of the things that So you can say stuff in a piece of parody that you could never say if you didn't make clear it was parody. I mean, it's really important that if you're writing parody, that you make clear it's parody. You know, if you're it's not gonna, you're not gonna be able to write something that has some false information in it, and then say, you know, sort of as like a after the fact defense. Oh, that was just, I was really meant to be employing parody. So you got to be clear that it was helpful to Hustler that it was helpful to them that they had, this is a parody, even though it was if you look at the ad, it's a very, very small type. I mean, this ad was at the time of what it was a takeoff on, was there were Campari had these ads about, it sort of used sexual entendre for celebrities to say the first time they had Campari. And so, you know, like so-and-so's first time was such and such. So, you know, it had this sort of sexual innuendo in it, but it was an ad for Campari. And so that's what this was this ad of Flint's was a takeoff. Did you see he died did he just die last week or recently, right? Am I hallucinating or did anybody else see that?
I had to
I'm
check.
hallucinating? Okay. No, I'm pretty sure he died last week or the week before. And you know, it's not a bad, the movie, you know, I forgot the name of the movie. I think I have the trailer linked in the syllabus. Might be US versus Larry Flint or something like that. It's not a bad movie. I actually have never watched it all the way through, but I know that I'm pretty sure that Justice Harry Blackman is the judge in the movie. And of course, Harry Blackman is the late justice known for having written Roe versus Wade. Any questions about Hustler v. Falwell? So parody, the other thing is like, that's in the same ballpark with parody is like hyperbole. You know, like political exaggeration. So for example, there was a case, there was a case involving some comments that President Trump had made. You know, I think it was the comments that he had made when he was saying to people in the crowd to beat up hecklers. And a judge had said, you know, this is just, this was really just hyperbole. So, you know, the hyperbole can be an out even even in sort of the political arena where one might expect things to have slightly tighter rules. So hyperbole, parody, satire, these things have the authors of are speakers of those forms of persuasion have more leeway with the facts than you know, does like a straight news reporter or the writer of a supposedly truthful biography. Any questions about that?
Well, you answered me. I was going to ask about satire. Would the statement by President Trump, let's fight like hell, would that be hyperbole?
Yeah, I mean, so that can sort of, so, you know, that's the answer is yes. And I think that's basically what the lawyers defending him at the impeachment said. And, you know, then they had a video of a bunch of Democrats saying, let's fight like hell. You know, or fight. We're really going to fight and get this done. And so yes, that's hyperbole. Of course, that's not in the context of defamation, but it is in the context, the context of where are the boundaries of free speech. That's in the context of incitement. So again, in the area of incitement, as in defamation, hyperbole and can sometimes be an out. So if a person who incites somebody to action, like President Trump seemed to be doing on the day of January 6th, if it is really just hyperbolic speech, then and he's not really calling on them to perform an illegal act, then it's not incitement. So this whole issue of hyperbole and parody and satire, they can come into play in relation to defamation. They can come into play in relation to incitement. We'll see a couple of weeks down the road that can also come into play in connection with copyright. We'll listen to Two Live Crew's Oh Pretty Woman parody, Oh Hairy Woman, which the Supreme Court, and again it was Chief Justice Rehnquist who wrote the opinion saying that it was parody, and so therefore it was it fit the fair use exception to copyright, and they didn't, and Two Live Crew didn't have to pay Roy Orbison for using all of his music from Pretty Woman. So it can come into play in a number of circumstances. Who did the case of the wrestling coach? Let me find our.
I've had a chance to somewhat look over it. I think I could.
Yeah, why don't you give us a little bit of a summary? That'd be great.
Okay, so Cleveland, Ohio, 1990. Well, this is whenever it went to court, I think. The trial court, sorry, Milkovich was a coach, a wrestling coach, and it looks like a columnist basically said that he had perjured himself in court whenever he claimed that he didn't incite any of this. I believe the Ohio State High School Association, kind of like Illinois has the IHSA or whatever, they the parents ended up suing, and there was an article in a newspaper that basically said that he lied in court, and he sues. I don't think it was the newspaper, it was the individual.
The reporter, the sports writer. Yeah.
Right. And let's see. Initially, he was saying he was defamed, and because perjury is a felony in Ohio, he was ruled a public figure as well. That was helpful. And the trial court said that the statement of opinion can't be viewed as libelous because there was no malice, no intention of malice. And so Milkovich, if I'm saying his name right, appealed to the appellate court, and the appellate court found that there was malice, and that was the Ohio 11th District Court of Appeals. And the newspaper ends up, appealing that decision. And trying to take it to the Supreme Court, but the Supreme Court would not hear it. Said there was no significant constitutional issues and denied hearing the case. And so then it was remanded back to trial court, and the trial court issued summary judgment again. And that's kind of where I think my notes lost up. I was not prepared. I'm sorry.
No, you did great. I mean, you
Okay.
you did terrific, and that's so what this case at the time of so Milkovich was this sort of like famous wrestling coach, and his teams would win the state tournament every year, and so he was like a legend in Ohio. And then there was this fight at one of the wrestling meets, and he claimed that he had not been involved in causing the fight. And as you said, there was like an Illinois, like an Ohio, hearing, sports commission hearing on,
Right.
How did this come about? And Milkovich claimed that he had nothing to do with it. And and then the sports writer who worked for, I think it was called the Lorain County Press
Yes.
or something, wrote that anybody who had been at something to the effect that anybody who had been at the wrestling meet and had then heard Milkovich talk to the Ohio Wrestling Sports Commission would know that he had perjured himself or he had lied. And so at the time of this court decision, it was widely believed by media and the First Amendment lawyers that basically you couldn't defame somebody with a statement of opinion.
Mhm.
And one reason that everybody thought that was that the Supreme Court had sort of said over and over again in dicta, not in one of its rulings, but just in words included in an opinion that, just an expression of opinion, that's not going to be something defamatory, but it's got to involve facts. Well, again, we're back to Chief Justice William Rehnquist said, yeah, we said that, but we really didn't mean it. That was just dicta. That's sort of a phrase that's sort of useful to know. The Supreme Court will sometimes, when it wants to say that something it said before didn't really mean what it seemed to mean, it
Mhm.
will oftentimes say, oh, that was just dicta. That had nothing to do with the ruling in the case. In other words, as we were coming up with the decision, we said some things that really don't have the force of law. So dicta are words in a court decision that don't carry the force of law with them. And so Rehnquist basically said that was just dicta, and we really didn't mean that, and that there's some kinds of opinion that can be the source of defamation. And so the kinds of opinion that can lead to defamation is if you state an opinion that seems to be based upon a set of facts when those facts are not true. I mean, arguably, I'm sort of doing this off the top of my head, but I mean, arguably there'd be a way in which some of the statements that supporters of President Trump made in connection with, say, Georgia and the election there, about it having been stolen because of Dominion voting, where that's alleging certain set of facts, and those facts turn out to not be true. That's the kind of opinion that can lead to a libel case. Um, and so this sort of panicked First Amendment lawyers who had thought, well, opinions is sort of a free area we don't have to worry about. And so, but as things have actually turned out, it hasn't turned out to be that big of a source of libel decisions against the press. So yeah, that was a good summary, Tabitha. Any other questions on libel, defamation, slander? Of course, all this, to a certain extent, it's all a little bit irrelevant. I mean, if you read the beginning of that piece I wrote about New York Times versus Sullivan, I quote some of the First Amendment lawyers as saying, people are basically libeling each other 1,000 times a day on the internet, and because because of Section 230 of the Communications Decency Act, which we'll talk about 3 weeks from now, because of that, the Facebooks and the Twitters cannot be sued for libel in the same way that like New York Times did, because they're protected from any libel that's in third party postings. So Section 230 of the Communications Decency Act says any kind of internet computer service, and that can be anything from Instagram to Facebook to TikTok to Google to Yahoo to the Daily Egyptian website or the Southern's website or the New York Times website, that a third-party posting to that site that contains something that's libelous, those platforms cannot be sued. The poster can be sued, but the poster usually doesn't have any money. So the platform, which has a lot of money, at least in the case of Facebook and Twitter and Instagram and all, they are protected from lawsuit. That's one of the things that I think that's a statutory protection, not a constitutional protection. I mean, everything we've been talking about today in relationship to New York Times versus Sullivan is the Constitution, the interpretation of how the Constitution affects libel. But Section 230 of the Communications Decency Act, that's just an act of Congress. So Congress, if the Democrats and Republicans could agree on it, and sometimes they both are actually mad at the social media people. If the Democrats and Republicans could agree on what to do, they could take away the Section 230 immunity and say, suddenly say, hey, social media giants, you're liable for anything that you put out there. Of course, that, the thing is, I mean, literally every day there are billions of bits of information that are on the web. There is no way for anyone to vet all that information. And so, if we want a web that has instantaneous speech, like we seem to, I think we do, there's no way to vet all that speech. And sometimes people talk about, well, there could be other ways in which to to put the brakes on. I mean, one way would be, I think we talked a little bit once before about the Digital Millennium Copyright Act. That's how copyright is handled on the web, which is basically, if you think your copyright's been violated, you file a notice. It's what's called notice and takedown. You file a notice, my copyright got violated. Then they supposedly take down the posting and the person, the poster can then say, oh no, I didn't violate your copyright. This was a fair use exception to copyright. I should be able to use it. And then you can sort of duke it out. So you could have a notice and takedown kind of procedure for for issues of libel on the internet. And that could be one change that could be down the road. Any questions about all this? Okay, so looking ahead, next week on Thursday, I think 4:30, we'll have our speaker from the Pulitzer Center, Marani Staub, talking about Portland and sort of the bundle of First Amendment rights that involves demonstrators and journalists at demonstrations that are sometimes peaceful and sometimes aren't peaceful. And then the week after that,
link to any of her work. Sorry,
you know what, I do
her work.
I do have some of her work. I will send that around to you guys. Yes. I mean, there's one piece, she sent me one piece which had, this was sort of some right-wing demonstrators driving cars through Portland. And you can literally, if you watch it carefully, you can actually see the person in the car pull a gun and point it at her, and then sort of pull the gun back. It's a little bit of a scary piece, but yeah, I've got a number of things from her, and I'll send those to you all in the next few days, maybe tomorrow or maybe tonight, so you can take a look at them. That's a great. I'm glad you mentioned that. So that'll be next week. The week after, we'll come back to our normal Tuesday meeting, and we'll talk about schoolhouse speech, and then move on from there. I guess we're sort of done a little bit early. Anybody have any other questions?
How's your day going?
It's going pretty good. I got to go start the barbecue fire now, though.
Cool.
I've got lots of jobs to do.
Just another question. Does me asking you that count as class participation?
Well, you got I think it's about 100 points for that.
Oh yeah, boys.
Yeah, very
Nice.
funny.
Mhm.
Okay, thanks a lot. See you guys next week. I'll send you some stuff on Staub.
Sounds good.
Okay.
Thank
Bye-bye.
you very much.
Bye-bye.